How can we abuse the court system to seek revenge or to seek vengeance against somebody? This is the topic for our video today. Recently, the Supreme Court came down heavily on a particular party that tried to initiate criminal proceedings, against a person, even though the dispute was civil in nature. So the classic case where these things happen is something like this. Let's say that you provide me, Ramana. Let's say you provide Ramana with goods or services. Ramana fails to pay you for the goods or services. So you go ahead and you file a civil case against Ramana because there's some money that is due to you. So you file a recovery suit saying that I've given these goods to him. You show proof, and that recovery suit is on its way in the competent court. But you think to yourself, Ramana is not really scared with a civil case. These things could drag on for years together. So let me do something else. Let me initiate criminal proceedings against Ramana Reddy. Let me file a cheating case against him. Let me file a criminal case against him for criminal breach of trust. So let me go to the police station and register a complaint. If that does not happen, let me go to a magistrate and let me file a private complaint. Now, this would be termed as an abuse of the process of law, because this is a case that is purely civil in nature. There are no criminal ingredients, and yet a criminal case is filed just to arm twist somebody, just to bring them to the table, just to put pressure on them, and just to threaten them with jail time. Now, does this mean that there are absolutely no facts where a criminal case can be filed alongside a civil case? No, absolutely not. So say, for example, that let's say I promised to sell you. So Ramana promised to sell you 50 kgs of gold. He takes money from you and he disappears. That's it. So in that kind of a case, you can definitely file a civil recovery suit for recovery of whatever money you've paid me, along with interest, and also file a criminal complaint against me because at the time of entering into the agreement itself, at the time when I promised you to sell you gold, I dishonestly induced you to buy gold from me, even though there was no gold to begin with. So at the time of entering into the agreement, they must have been, there should be an intent to criminally take money from you. And unless we can establish that, it is difficult, or it is actually wrong, to file a criminal case where there is a civil dispute. Now, in the facts of the case before the Supreme Court, so what happened was there was an investment firm that was looking to invest some money with the company, and they invested about, I think, 2.5 crores into the company. The company and they entered into a memorandum of understanding, an MOU. In the MOU, there was one specific condition that said that the company must, put out an IPO and a public offering within a specific period of time, which did not materialize. So dispute started between the investment firm and the company, and so what happened was, I think there was a civil case that was pending. So what the investment firm did is, so first they went and filed a private complaint in Delhi. The the court, I think that it was the 30 Hazari court, that said, there is no, this is not a criminal case, this is a civil case. Therefore, we're not going to register, any kind of a case against these people. Since that did not happen, then they went to Calcutta, which is a different state, and they tried to file another criminal complaint there on the same set of facts, and they literally suppressed the fact that they had filed a complaint in Delhi, and that the Delhi court refused to entertain. The court in Calcutta entertained their petition, and offences were registered against the company and their directors under, I think it was section 420, for cheating and for criminal breach of trust. In those set of facts, the Supreme Court held that, look, at the time of entering into the MOU, the company did not have an intent to cheat you. They did not enter into the MOU specifically thinking I'm not going to do the IPO. That was not the intent there. This is only a civil dispute. As far as criminal breach of trust is concerned, the Supreme Court said, this is not a case where there was, entrustment of property, and even if there was any entrustment of property, it has not been dishonestly misappropriated for some other purposes, apart from business. So the Supreme Court said this is a classic case where the dispute between the parties is civil in nature, the refusal or the failure to do an IPO within the stipulated timeline. And that has been given a criminal color by the investment firm, just to put pressure. And they've also done forum shopping, which is they didn't like the decision in Delhi, so they went to Calcutta. They suppressed facts and so on. So I think so to conclude, and I think the big picture here is there are cases where the set of facts allow for filing a criminal complaint as well as filing a civil suit on the same set of facts. But it is important to remember that if you choose to go down the criminal route, then you must satisfy the ingredients of the criminal offenses that you are alleging that have been attracted in the particular case. So unless that happens, it's not a good idea to abuse the court system and to arm twist people, because that can really blow back, and that could result in several costs being imposed against you if that FIR is registered and if it goes before a court. I hope that was helpful. Thank you for watching.